Hello, I'm Stephen Hunt, and welcome to Dodging Bullets, the Insolvency Practitioner's Guide to Surviving the Week. This week, we're joined by the infamous Luke Harrison, who I've known for far too many years. He's Luke, do you want to introduce yourself? Who are you and what do you do?
Yes, I'm Luke Harrison. I'm a co-founding partner of Keelan Harrison. We're a commercial and insolvency disputes boutique. And I've been acting both for and against IPs for getting on about 20 years.
And also with me is Andy Goodson. And we're going to focus on the case of Lawrence Factor versus, how do you pronounce it? Hussam Haddad, is that right?
Hussam Haddad and various others.
Okay. Where you go, Luke. Do you want to give us the background to the case, and then we'll get into the issues that arise?
Yeah, certainly. Well, I acted for the second respondent, who was principally the only respondent represented by solicitors at trial. His name is Andrew Prodromou. Andrew's a retired accountant who was brought into the business as a consultant and took the title CEO during a period when the business was recovering from COVID and was expecting to receive a substantial payment from HS2 arising out of compulsory purchase of one of their buildings. During that period, the business was suffering from cash flow difficulties. And as a consequence of that, it missed various payments, but subsequently received in the region of about £3 million in compensation from HS2. You think that was all right, and the company would then have good fortunes, but unfortunately, due to a dispute between family members, the company was later placed into administration. As a consequence of that, various claims were brought against directors and Andrew, who wasn't a director but was alleged to be a de facto director. The claim proceeded to trial, and the usual issues that arise in cases like this were set to be determined at trial, including whether or not the company was insolvent at various times. Because of the back of the alleged insolvency, there were transaction and undervalue and preference claims brought against various third parties, and overlapping misfeasance claims brought against the directors and Andrew in his capacity as an alleged de facto director. But where things went really wrong for the IP was the emergence of serious disclosure failures in the run-up to trial, including the failure to disclose a document which was arguably a known adverse document, being a report that Quantuma had undertaken for the purposes of HS2 to demonstrate that the company was solvent at exactly the time that these various payments were made, clearly a probative document. And the disclosure failures were so bad that the trial was adjourned on the liquidator's own application, with various orders made, including orders for indemnity costs that were wasted, and an unless order which required, amongst other things, Mr. Factor to file a witness statement explaining the reasons for his disclosure failures. The matter then came before Chief ICCJ Briggs on the 27th of February, where we made the submission that Mr. Factor had not complied with his obligations under that unless order, including providing full and frank explanations as to his disclosure failures, and Chief ICCJ Briggs agreed, with the consequence that the claim was declared to be struck out.
Well, let's just so in summary then. So it starts off in admin with a different insolvency practitioner, and then Mr. Factor is appointed liquidator. I don't know Lawrence Factor, and I've not spoken to him about this case. So the creditor, he's the accreditor's appointment, nothing to do with the directors. Is that
correct?
Okay. So he pursues the claim. He's appointed in 2021. Puts together the claim. I don't know when the claim was issued. I'm not sure that's in the judgment. But it all gets to court at the start of this year. So, IP's not experts in law. Do you want to explain a little bit about why disclosure is important, or has the law changed on disclosure? Why is it so important in this particular case?
Well, claims in the Business and Property Court are governed, unless the court orders otherwise, by PD 57 AD, which was a disclosure pilot, but which is now mandatory in that court. And where an order for extended disclosure is made under PD 57 AD, there are obligations to comply with that order and give disclosure on the list of issues for disclosure that the court has ruled upon at the case management conference. And in so doing, you have to sign a disclosure certificate which sets out what you have done as part of your disclosure process and declares that you've complied with your obligations under those rules. Now, in serious cases where you deliberately or recklessly fail to comply with your obligations but certify that you have, there can be a real risk of contempt proceedings, and certainly, as transpired in this case, the claim can in fact be struck out by reason of that abusive process.
Okay, so I'm looking at the judgment now. The document signed by the IP is, I certify that I am aware of and to the best of my knowledge and belief have complied with the disclosure order. In practice, who does that? Is that the IP staff, or the lawyer? How does that all work in practice? You act for IPs. How does it all work?
Well, in practice, it's something that the solicitors generally do on behalf of their clients. And indeed, the courts generally expect the solicitors to undertake the process unless there's a reason why it's not possible. For example, the client can't afford the solicitors to do the whole process. And that's because it's a technical exercise in determining in relation to each document whether that document is relevant or not for the purposes of the issues. Where the exercise is undertaken by a client, it's important for the solicitors to brief the client exactly on what their disclosure obligations are. And this doesn't appear to have happened in this case, because Mr. Factor, in his evidence, said that he didn't understand his own disclosure obligations.
Okay, so, I mean, I'm an IP. I have lots of litigation ongoing. I'm not required to read every document personally and say what each one says and how it's relevant. That's not how it works, is it?
No, in practice, solicitors will normally use any discovery platform and start off with a first review of the material after a keyword filtration process that the parties have agreed in accordance with what's known as Section 2 of the Disclosure Review document. That first pass review filters out the irrelevant material that was fed out of the keyword search procedure and leaves relevant material to be reviewed. And again, that's a task that's normally undertaken by more senior members of the solicitor team. And ultimately that's presented to the client, the IP or otherwise, for sign-off as their disclosure. And in those circumstances, an IP can justifiably rely on the work product of the solicitors.
Sounds expensive. What if you're on a no-win, no-fee? There's no money in the estate or something. I don't know if that's the case in this case, but in this litigation. But it sounds like it could be a pricey step.
It can be, and actually the software involved for doing a proper disclosure exercise where you're ingesting a large volume of electronic documentation and reviewing it via a disclosure platform can itself be quite expensive, with sort of monthly data hosting costs typically £2,000 or £3,000 a month. So it's often only available in cases where there's sufficient assets in the estate in order to be able to fund the disbursements. It does prove problematic in cases which are funded solely on a conditional fee agreement basis. It is possible to undertake a disclosure process without using specialist software, but it is problematic for IPs in circumstances where they do hold a large amount of material from the insolvent estate, whether it be a company or whether it be a bankruptcy estate, that might be relevant to the list of issues for disclosure, because without using the specialist software, it can be quite difficult to do a proper search of the material.
But in most cases, I mean, most insolvencies, you're suing the directors or people close to them. The IP wasn't there at the time. The IP gets the documents mostly from the directors. They have a duty to hand them over. And then isn't this sort of a bit slightly unnecessary, because you're being required to show the same documents back to the directors that they created. So does it matter that much in a claim where it's against directors?
Well, very often when you are appointed on an estate, you'll get hold of the books and records of a company or an individual, and those can be voluminous. I mean, historically, the books and records would have been in paper form, but nowadays invariably IPs are taking cuts of data from servers with email, often forming the vast majority of the data. Now, in circumstances where you're bringing a claim based on certain transactions, the email universe can actually provide quite useful data and documentation in relation to those individual transactions. And I often see them searched by reference to the value in pounds of the transaction, because that's often something that's selected as keyword. But if you're not searching those email records, you're potentially in breach of your obligations to give disclosure in accordance with PD 57 AD.
Let's move on in this case then. So essentially, we know disclosure wasn't undertaken properly, and you discovered that fact prior to trial. What happened at trial, or on the first day?
Well, on the first day at trial, we drew to the court's attention matters that had really come to a head over the weekend after repeated attempts in correspondence to request the provision of certain documents, which we come to learn it existed. I think it dawned upon the counsel team representing Mr. Factor that it wasn't going to be appropriate to proceed with trial, because professionally counsel had to accept that there wasn't going to be a fair trial without disclosure of the material that had been withheld.
And what happened next?
It was quite an unusual submission to make, and initially the judge thought that the request was coming from the respondents, but it was clarified to him pretty quickly by the applicant that it was the applicant's own request to adjourn trial, and he quite quickly came to the conclusion that that was going to be necessary. And so 2 of the days marked for the rest of the trial were used to deal with consequential matters arising from that decision to adjourn.
So just pausing there, do you think that was the right thing for the IP and the legal team to do in those circumstances?
I think it was the only thing that they could do, because in circumstances where the disclosure hadn't been given, there were going to be very significant adverse inferences drawn had the trial proceeded, and quite frankly the respondents would be justified in making the submission themselves that the trial shouldn't proceed. So it was pretty much unwinnable unless they were to remedy their disclosure failures. So I think they took the decision that the best thing was to take the hit on the wasted costs arising from the vacation of trial, and to see if they could regroup and come back having discharged their disclosure obligations. But that ultimately didn't happen, and the door is now closed for them.
Okay, so that's effectively day one of the trial. What happens next? They have to go back, don't they, to deal with the mess?
Well, needless to say, ICCJ Briggs was not impressed with what had happened. It wasted a significant amount of court time and caused significant wasted costs. So he ordered Mr. Factor to file a witness statement explaining, and the crucial bit is it was to be explained on a full and frank basis what happened in relation to disclosure. And that was in part because he also directed a further hearing, which was termed in the order as the abuse hearing, to decide whether or not the claim should be struck out in any event, notwithstanding the adjournment, by reason of the seriousness of the failures. And what he wanted to get to the bottom of was whether or not these failures were inadvertent or reckless or deliberate. And for that reason, Ms. Factor had to file this witness statement.
And what did the witness statement contain?
The witness statement was supposed to contain a full and frank account of the disclosure failures, and there's authority on what full and frank means. It often arises in the context of full and frank disclosure in applications for freezing orders and other interim relief, and it basically means putting your cards on the table. and having served this statement with the assistance of his solicitors, it was quite clear to us in counsel that the statement was neither full nor frank, and indeed that was the conclusion that Chief ICJ Briggs reached when we asked him to declare that the claim was struck out.
Okay, well, I mean, people can read the judgment for themselves, so that's a blow-by-blow account, really. So my real question from the dodging bullets sort of perspective is, whose fault is it? Is it the client or is it the lawyer, from your perspective?
From my perspective, if I was acting for an IP and they found themselves in this situation, unless they had disregarded my advice, it would be my fault. Disclosure, as I mentioned earlier, is something that is normally within the ambit of the solicitors, and they undertake that on a delegated responsibility basis for their clients, having asked all the right questions. And even in those rare circumstances where the client does the work themselves, it's normally on the basis of very detailed briefing notes that explain exactly what process they need to undertake so that they understand how to discharge this very complex burden.
So if I can ask you to swap sides for a moment, and obviously, as you've said, you would, of course, advise the client correctly and unless the client ignores you, but don't place yourself in the position for the other side's lawyer. Place yourself in the position of the IP. What should they have done differently with their lawyer? They don't know this. They don't know what frank and you've just said. Full and frank disclosure has been set out in case law, and it means all sorts of things. This may not be a term that's familiar to an IP. We don't do litigation, but it's something. I don't know how many cases he's brought. I don't know if he's up to date. I don't know if he brought it under the new disclosure regime. What should he have done differently? He's following advice. If the lawyer says it's okay, isn't it?
I think there's a different degree of sophistication amongst IPs where it comes to litigation. I know your firm, Steve, acts in a lot of contentious mandates, but there are many IPs out there who get involved in litigation less frequently. And if you're one of those IPs, you need to be asking a lot of questions. Your lawyer should really, quite frankly, be proactively providing the advice that you need in order to satisfy your obligations to the court, which is particularly important given the status of IPs as officers of the court. But otherwise, if you are not sure as to what your obligations are at any particular process, it's important to ask those questions of your legal team.
One of my key observations from reading this was exactly that point, Luke, as I think the best takeaway for insolvency practitioners from this judgment is not that they should all now read up on the practice direction on disclosure and start reading the quite epic document that is the DRD that governs it, but it is instead to be more alert to the fact that you can sometimes, often unwittingly, be let down by agents, experts and solicitors, and where you have any doubt or unfamiliarity over what you are doing is to ask questions. I have had personal experience of undertaking disclosure and actually doing the disclosure review myself by doing litigation, as well as having lawyers do it. And when I did it for myself, when I was doing the actual review, because I had better knowledge of the documents than the lawyers ever could, because it was a rare case where it was what we had done, I checked in with the lawyers beforehand. I said, this is how I'm going to do the search, and said to them, I'm going to keep a diary, if you like, of every decision I make. Whenever there's a judgment decision as to whether I think something goes in or out, I'm going to record that, and made sure that my lawyers were happy with that, and they were. And that way, when there were, as inevitably there will be, questions over disclosure later, it was all well documented and done. And I didn't know disclosure very well before that, but it was just to keep asking the questions, what should I be doing? What's expected of me? And that helped make sure in that case it's better. And I think that is the case. The takeaway from this is keep asking questions if you're not certain.
I think I would take that wider. You have to remember, insolvency practitioners are general practitioners. Even, as you say, I do a lot of litigation, but I'm not a lawyer. So I try to understand what lawyers are saying but I don't try and be the lawyer. My job is to ask the searching question, or even the nonsensical question, just to make sure that I understand that my lawyer's on it. When it comes to complex tax matters or selling any asset, even a property, I'm not an expert in selling a property. I sell a lot of properties, but I'm not a trained estate agent. Our job is to be the expert client. So I'd agree, whether or not you're involved in litigation or realising any asset or any aspect, you've got to take advice and rely on it and challenge it. But you are relying on advice. These people are, you're both charging the estate, I suppose. It's an estate asset, not the personal asset of the IP. They may be the client, but they're representing an estate to which you both have duties. And I think that's quite an important point to emphasise, that you want the different experts doing their job.
And I think it's important for IPs to understand that when you are defending a claim brought by IPs, the IPs have got the burden of proving the claim. And along with the burden of proving the claim, the IPs have got the burden of ensuring that documents within their control find their way over to the other side. And defendant lawyers in those circumstances will look for holes in the process. It's a way of undermining the credibility of the IP's claim based on gaps in the evidence. And one of the areas where this is often overlooked is whether or not a company is insolvent. Now, it may be quite easy to establish that a company is insolvent if it produced regular management accounts. You can simply tell from those documents. But in many of the cases that I see arising out of less sophisticated entities, the management accounts are simply not there. And other mechanisms are used to try and establish insolvency. For example, bounce checks or creditors not being paid. And it's in those circumstances where much wider disclosure may be relevant to try and get to the bottom of whether or not the company was in fact insolvent.
Did you just say it could be easy to define insolvency? I thought even the Supreme Court didn't agree with itself as to what insolvency was. But no, I get your point. But yeah, it's very difficult for me to comment because we have systems and we do this all the time. But I'm trying to appreciate the position of an IP that doesn't litigate so much. So I think it's the job of the lawyer to understand the client's needs. And there's lots of little steps at the very, very beginning. The lawyer should, starting from that position, then move on to appreciating the skill set of the client, the IP, and to be frank, the risk they put them to. When you mess up the sale of a property, oh dear, and there may be consequences. You mess up in court and your name's splashed all over the headlines, and then everyone talks about this particular case in all the seminars. So there's an extra onus on the lawyer as agent to do things right.
Yeah, I would definitely agree with that. And one of the things that struck me as I first read through the judgment was where the judge set out the disclosure that had taken place, and the fact that, I think, Luke, it was your client, had disclosed in excess of 4,000 documents. The other respondents had disclosed 155 documents, and the IP disclosed only 56 documents, despite holding 49 boxes of records, at least one server, at least one computer. And a key example that came out is within the witness evidence that the IP had submitted, there are schedules of transactions from bank statements, and the disclosure didn't even include the actual bank statements. And when I looked at that, my initial thought was, what was the lawyer doing? The disclosure documents, I think, are all from around April 2025 is when disclosure took place. So 8 months before the trial. And at no point has the solicitor looked at the disclosure that's gone out from their side and what's coming from the other side and seen this huge numerical discrepancy and thought, I should probably check in with my client and what they've actually done. Or at least that's how it appears to me looking. I mean, Luke, what would your response have been if you'd seen those numbers?
Well, it was, I think, pretty obvious that there was something seriously wrong with the disclosure simply based on volume. And I think it arose principally from the rod that the IP made, no doubt on the advice of his lawyers, for his own back. in that the IP decided to plead quite a wide-ranging date period in relation to insolvency, and also made allegations of de facto directorship. Now, in relation to the latter, where you allege de facto directorship, it generates a lot of disclosure, because you have to look in quite granular terms at what an individual was doing in a business in order to make a call on whether or not they were a de facto director. And having made that allegation, my client was put to the burden of disclosing any documents which either showed that he wasn't acting as a de facto director, or perhaps showed that he was. And that's why such a large volume of documentation was disclosed. The IP and his lawyer really ought to have been alive to the fact that they had a corresponding burden on their side.
Okay, let's take the chronology one step further. I'm now asking you to wear a different hat. A Mr. Factor calls you and says, I'd like someone to act on my behalf. Do I have any claims against anybody? Do you think an IP in this situation, well, I suppose there'd be several claims. One would be the IP's costs, the Kate Estates costs, because the IP is issued in their own name, so they're going to be liable. I don't know if there's ATE. But also the estate could have lost a perfectly viable claim, either against your client or the other clients. So the consequences for the IP and their lawyer for getting something wrong could be quite significant.
You're absolutely right, Steve. When a claim is struck out on procedural grounds, in theory, there is a claim that can be brought against the solicitors if it's ultimately their fault, for the loss of a chance of being able to bring the underlying claim. Now, obviously, in the loss of a chance claim, the court's not going to determine whether or not the underlying claim would have succeeded, but they're going to determine the percentage chance of that claim succeeding in order to be able to quantify the loss arising from that. And you rightly mention after-the-event insurance, because as you'll appreciate from the work that you do, after-the-event insurance policies often include terms requiring the litigant to comply with the civil procedure rules, which includes the relevant practice directions and orders of the court. And there's an obvious reason for that. It prejudices the insurer if they don't. So in circumstances where they get struck out having not complied with those orders, questions can be raised as to whether or not the cover still responds. And in circumstances where a lawyer is representing an IP, or any litigant for that matter who has the benefit of insurance, part of the lawyer's duty is to ensure that their client complies insofar as it's within their control with the terms of that insurance policy, so as not to leave them exposed to adverse costs if the worst happens.
Well, that takes us slightly onto a topic that Andy and I have both looked at for many years, which is the consequences to an IP when they bring this case, let's say on a CFA, and it's lost, and what happens next. It's lovely saying you've got ATE for your costs. It's lovely saying you've got a lawyer and a CFA, but we've certainly lived through cases where we've even had a litigation funder say, thank you very much, I'm gone. And the lawyer terminates the CFA, and the IP is naked before the judge, hopefully with an ATE policy, but they've got 21 days to pay and possibly disputes to be had. So the risk of litigation, even if you arm yourself completely, is not there. A lot of terms litigation funding don't include the costs of consequentials. A standard CFA for an IP says that if the lawyer doesn't fancy proceeding, they don't have to work on the consequential hearing or anything else. It's a risk, and it's a step that they take. And you don't win all the cases. As an IPs, you should bring the cases that follow a fairly strong track in courts that are experienced in these particular niche. So you should have, any IP litigating should have a high win rate if they do their job properly. But when it goes wrong, the IP isn't necessarily control, and they are insolvent estates. So there's no indemnity to benefit to repay them if the other parts don't work properly.
I think you're right, Steve. And one of the things I always say in relation to insolvency claims is that if it's a good claim, it's normally an obvious claim. Very rarely do you end up bringing a claim which isn't particularly obvious and you can't properly articulate. Generally, weak claims sort of are filtered out that way. But sometimes they get through. And one of the things I've always wondered why IPs don't do is assigning claims to the company in liquidation. So there are obviously certain claims that you can bring directly by the company in liquidation, and others that are office holder claims. But why not assign the claims to the company? Now, I appreciate that brings with it a security for cost risk insofar as the company is pursuing the claim. You can obtain after the event insurance and appropriate anti-avoidance wording and or deeds of indemnity that address the security for cost risk. And then the IP is insulated in the event that the worst happens by way of the structure that has been set up in advance.
I think the legislation coming in 2016, which gave more power to assign office holder claims, and of course Section 212 claims are company claims that just have to be brought by the IP, so they don't have to assign those. They are really company claims. You bring them as the company, so it may well be a sort of professional drag, a lag in understanding that need, or maybe there's something slightly distasteful an IP saying, I don't stand behind my own claim. I need to put it in a vehicle where I couldn't be liable. But then again, is it the job of the IP to put their neck on the line every time and hope the ATE cuts it? That's not our job. We're not trained. We're trained at JAB to learn about these cases. But if you look in the guidance is about investigating. There's no guidance. There's no statutory guidance. There's no SIP on how to litigate. The lessons pretty much end with give it to the lawyer, instruct a lawyer. And then all our training starts off from the principle that lawyer will take over from there. We'll be the client. But it's too complicated and too specialist for the IP to understand.
And at the risk of bringing in what is my more geeky, techie side, this does fall in line with something Steve and I have discussed previously about how before the end of every administration that does not drop into a liquidation, that administrators should always assign any and all claims they might have to the company, because that stops the problem where if an administration ends, you have a period where the company is out of administration before it's dissolved. And it then means if it's ever restored, it can't be an adjoining procedure. And so all of your antecedent recovery look-back periods that you had in the administration are lost. Whereas if you assign all the claims, then even if it's brought back, those are now the company's claims, not the office holder claims, and it's far easier to protect those. I think the reason more don't do it is probably it's not on the radar. I don't think many lawyers think in the way you do, Luke, about that. And because they're not talking to the IPs, there's not very many IP firms who spend a lot of time really thinking about the finer points of exactly what goes in litigation and what other tools there might be at their disposal to improve their position.
So, Andy, I don't think there are any circumstances really in which an IP should expose themselves to personal liability in relation to claims. As Steve said earlier, the IP is acting on behalf of the estate, and the IP is going to be an employee or a partner of a firm earning profits for that firm. So there's nothing in it for them personally. And so there are structures that can be set up when the claim is about to be pursued that gives them that additional layer of insulation, and I think they should always be explored. And indeed, if the lawyer is acting for the IP, I think it's their duty to make sure that the IP has taken steps to protect themselves from personal liability. And just one final point on this is the personal liability doesn't necessarily just arise from adverse cost risk. I have seen some litigation funding agreements, which are non-recourse litigation funding agreements, which in certain circumstances seek to make the IP liable. And so it's also very important that the lawyers very carefully look at those documents as well.
And continuing there on the topic of protecting the IP, particularly noting the title of this podcast, one of the worst things you can do when you've made a mistake is to make another one. And one of the other standout features from the Sweetland judgment was the manner in which that the IP approached what was requested or required of him from the order that was made on the first day of the trial, is that it's probably made things worse, in that he was asked to put out full and frank disclosure of various matters pertaining to the disclosure, and effectively replied with, some of these things are in my possession but unlikely to be relevant, some of them aren't in my possession, some of them already been submitted in evidence, some of them aren't relevant. Doesn't go into any proper detail to set out the position. And what the IP should have done, if they had a clear head at the end of the first day of trial, I think, looking back at this, hindsight is always 2020, is they should have notified their PI insurer immediately that something has gone catastrophically wrong with a case. Even if you don't think you're likely to get personal cost issues or anything like that, it's always a good idea to notify your PI insurer as early as possible on almost anything where you think there might be a problem, because it helps avoid them potentially trying to avoid cover. Often you'll get some legal help. I can see that whilst the IP was represented at the first hearing, they weren't represented at the second. And so it looks like the IP might have been left all on their own to do this witness statement. And because in a way, it's kind of, the IP was in a hole, and with this witness statement, they've carried on digging. And if a regulator decides to pick this up, many people in the industry have views on how appropriate it is for regulators to just look at judgments and go and investigate. But if this does come into the hands of a regulator to review, that second witness statement might actually make things worse than they had to be for him. So with regards to protecting oneself, the PI insurer is actually a very good shield rather than someone you have to crawl to in the most embarrassing of situations.
Just coming in on that, Andy, it's very rare for a PI insurer to provide cover in relation to liabilities incurred in respect of litigation, because that's what ATE insurance is for. It can provide cover in certain circumstances where a wasted cost order is made, because ironically, the wasted costs order potentially arises from the IP's own negligence rather than the normal litigation risk. And wasted costs would not normally be covered by ATE insurance.
And I think, that point, Andy, we should repeat many times in all the various episodes that we have. Whenever it goes wrong, your first call is to your PI insurer. And also, Luke's on the other side in this. He wants to get paid. We don't know how much money the IP's got. We don't know what your costs are. Don't want to ask, but I'm sure they're very reasonable, Luke. It's in your interest to make sure that they've got some sort of insurance cover, ATE or even PI. So friendly chat to the opponent. I do hope you've spoken to your PI insurers. Would be in the interest of your clients. And I've certainly said to regulators over many years, whenever there's a complaint, before you proceed with the complaint, before you ask any questions to your member about the complaint, is ask them, have they notified their PI insurer? Because the PI insurer will cover, in many circumstances, the costs of the regulatory investigation, give proper advice, independent advice, as well as deal with the litigation consequences. It's very much about not making it worse. You can't make it perfect. It's a busy, complicated, difficult position that we're in. But what you should never do is make it worse by not telling your PI insurer.
Yeah, and I think when I used to do a lot more insurance litigation, I still do a little bit of insurance litigation, but back then I did a lot of notification claims, and the golden rule was notify, notify, notify. Because the normal provisions of liability insurance contracts are that you should notify circumstances which may give rise to a claim. So even the hint of a claim or the hint of a circumstance is something that should be notified. And it often doesn't result in an increase in the premium if you've just made a notification.
That's the point. A lot of IPs believe that if they notify, they'll increase their premiums. My experience is very much the opposite. You notify in every grizzle and complaint, and then at the end of the year you say they can go anywhere, that didn't go anywhere, that didn't go anywhere. The insurers like a healthy appreciation by the client of understanding when to notify. So my advice to anyone listening is notify, notify, notify. Andy?
Yeah, and my final point was on when talking about the potential costs or orders that might be made against the IP, as we touched on earlier, there is a chance that this claim was a good claim. And if the actions of the IP have caused the claim to fail, the estate may have a claim against the IP. And my understanding from reading the judgment, from the numbers that are set out in there, the total amount the IP was claiming was north of 1.1 million. So that's, if you can get your insurer to help you try and bat off any claims like that as early as possible, to reinforce the message, notify, in the hope that it helps make the situation get better and not worse.
I remember being called in by a regulator into an IP firm where they had their first regulatory inspection of the IP, and they effectively took his license at the inspection. They called me from his offices saying, "You need to come down. Can you act as successor?" It was that bad. And I spoke to the IP's non-qualified partner, and he was basically saying, I won't do the Brummie accent, but he was in the Midlands, but he was saying that he told this IP about this and he told this IP about that. And I said to this partner, I said, "But you do realise you could be jointly liable for all this. You've been saying that you knew this and you knew that was wrong and you knew it was doing things wrong. Have you alerted your PI? Because as far as I can see, it's out of date. It expired last month." And the partner said, "Oh, you're worrying me now. Wow. Well, go away and get some advice, but you shouldn't be there. If you're paying all these premiums, for God's sake, make some claims on them just for your own peace of mind." Let's move to closing points now, I think. I wanted to sort of just say that my concern on this case is that I don't want it to be used by IPs as a reason not to litigate. Mistakes happen, and it's not always the IP's fault. Whether or not that's a factor in that regulators take into account in terms of acting on advice, but certainly with regard to cases generally, this is a lesson about, mistakes happen. That's how we all learn. We see case reports all the time about mistakes made, but there's a lot of cases that do succeed and they're done right and the legal action is right. So it's very important for us to emphasise that IP should not be shy of bringing claims, but they should learn the lessons from other mistakes and read around it. And when in doubt, just ask. Play dumb. Is that right? Is that right? Test, and test.
I think you're absolutely right, Stephen. As I said earlier, most good claims are obvious claims. They're not difficult to put together. They're not difficult to pursue. They're not often difficult to settle if you've got sensible opponents on the other side. And if a claim does just not feel right, and you just can't get all the bits and pieces together just to make it hang right, I think IPs should sit back and ask themselves twice, is this a good one to proceed? And make sure their lawyers are advising them properly as well.
And I think my key takeaway from this is, for IPs, is you don't have to be a lawyer to be a good client to your lawyers. Lawyers would much rather have a client that asks them the question one more time than might be comfortable than a client who pretends they've understood and they end up in all sorts of problems. A case where they have to explain things an extra time, but they win at the end without any problems is, one of the better cases that any lawyer will have.
You don't want to be the one who remains silent and says afterwards, "I thought it seemed a bit funny." That's just not where you want to be. Well, thank you, Luke. Thank you, Andy. I thought that was quite interesting. Next episode, I think it might be you, Andy. Do you want to mention at all what you're hoping to do in the next episode?
The aim is to look at, within insolvency and other professions, parents dealing not just with children, but children with additional needs, and balancing those sort of extra tugs on your time and your attention across work and the home life.
I shall look forward to it. Thank you very much.